All right, architectural guidelines, do's and don'ts. Know the governing documents.
Yeah, that's going to be critical. I mean, all the decisions that are made are required to be supported by the governing documents, and so that's part of the commitment to being on the board and being on the architectural review committee or architectural review board.
Applied guidelines consistently.
You can't have decisions that are all over the place, two different decisions that are made on the same issue. That's opening the door to being found by a court, if it were challenged, having made a decision arbitrarily or capricious. You also want to avoid selective enforcement. It's a way to get sued and accused of discrimination.
Communicate clearly.
To the extent that an application is denied, it is critically important to make very clear the reasons why, and also to communicate to the homeowner, this is what it would take in order for this to be approved. The goal should be, if the application can be modified to get to an approval, don't make the homeowner play a guessing game.
Because you're interacting with the owner then in a positive way. You're trying to solve a problem together compared to just telling them no.
It's very important that the application itself be well drafted. The South Carolina HOA Act, so since 2018, it's been required that all governing documents, including rules and regulations and architectural guidelines, that are now required to be recorded. So that goes a long way toward making sure that everybody what the rules are.
How much detail should an architectural committee go into, I guess, in particular, a denial?
It's important to document the decision and to be detailed as to why. Sometimes that could be more elaborate, and sometimes it's fairly simple and straightforward. Review committee should expect, especially in the case of a denial, that the decision is going to be scrutinized. The homeowner might possibly sue the association over it. The decision should not leave any room for questions as to what the reasoning was, what the basis was, why the decision was made. Yeah, that should be documented, and it should be as detailed as it needs to be to make clear what the basis of the decision was.
Is that information that other residents are entitled to?
No, that information in terms of a decision is generally not something that is available to all the other residents. It would be considered, executive session material, but it's there in the file. It should be kept. It's part of the association's record. It's important to have that and to maintain it because there needs to be consistency over time with regard to future decisions when the same issue comes up.
Maintain timeframes. So one person gets their application process done pretty quickly. The other applicants have to wait 6-7 months.
It's pretty typical, a time frame provision in there that states if a decision is not made within deadline, which is often 30 days or 60 days, that the application is approved, and that's a fair. You can't just make people sit around indefinitely. That's inequitable. It's unfair, and it's a violation of their rights as a homeowner. Really cost them money. Contractors can't wait around for everything to move on to the next project. However, an important point, if the application is incomplete, then that's an opportunity for the committee to respond to the homeowner and say, the timeline has not started yet because it doesn't start until you submit everything that has to be submitted as part of the application. And that should actually be specified in the guidelines. Then the homeowner should be notified of that in writing before the deadline runs.
So is it a fair statement if a committee is falling far behind on applications because they just don't have enough people, that the board should consider expanding how many people are on that committee?
Absolutely.
Seek legal advice when needed. I throw that in on everything we do. I don't think we need to go over it. I want to get into different accommodations, but let me just get a couple other quick ones out of the way of the don'ts. Don't ignore violations.
That's part of the fair and consistent enforcement. There are reported cases of associations that have been held to have waived the ability to enforce the rules if they ignore it in other circumstance. Somebody does something and you violate them and it's challenged and they can show evidence in court that it was ignored on all these other instances, there's a good likelihood that the judge is going to consider that to have been waived.
Okay, can I hit you with a couple of my scenarios?
Let's go.
All right, a child has a disease and cannot interact with other children. Maybe it could be a psychological issue, it could be a physical issue, but let's say it's a legitimate disease. They can show the board they have proof of this from a doctor, okay? And the owners request an accommodation for a play set in their backyard based on the fact that this is something that your child is not going to get to experience elsewhere.
And the play set is would otherwise be prohibited.
Yes.
Chances are, doctor's letter says what it needs to say, which, you know, it indicates what the disability is, and it connects the disability with the requested accommodation, then that's going to have to be approved. Yeah, no doubt about it. The FHA will require that.
This is one I actually just recently saw. I changed it a little bit, but it's pretty much the same. An HOA has had several home invasions resulting in injuries to owners. An elderly couple with limited means to protect themselves, they request a security screen door. You know, one of these doors some people consider unsightly with the bars. The fact that there's a known danger going on and they don't have any other means to protect themselves, would the association have to allow an accommodation? And I think this is one that associations really don't want to see these doors popping up around their neighborhood. So I'm curious.
Limited economic means is not a disability. That is not going to be treated by a court as a request for an accommodation due to a disability under the FHA. I mean, the association could make a decision to allow that if they wanted to, but if they don't want to, the homeowner is not going to be able to properly characterize that as an accommodation request under the FHA for a disability. Because
an owner breaks their leg and they can no longer maintain their property adequately for a limited amount of time.
So what would be the accommodation that they're requesting? Just that they don't have to cut their grass for
the grass isn't going to look that great. Maybe some of the other landscaping aspects are going to kind of fall in disrepair, but it's going to be for a limited amount of time.
That's a tough one because the person is on crutches or in a walking boot or a wheelchair or whatever. You could say that that's a disability, but there's also lots of other ways to get your grass cut. I mean, you know, it seems to me like that's going to be a hard sell on the part of the homeowner to say, well, you know, because I was injured that I can't maintain my yard. I don't like their chances of succeeding on that one.
This is another real case that came up where an architectural committee was demanding engineering drawings for every request. And they ended up getting sued on the fact that owners felt that was too much of a cost for them to incur. It wasn't required for a lot of the requests they were asking. Could you take it from there? What do you think of that one, Sean?
So, I mean, that makes sense to me. A common sense approach has got to be taken. Engineering drawings are not necessarily required for every project.
An owner requests a religious accommodation
Okay.
for, let's say a sukkah. A sukkah is like a religious structure, but it could be any other kind of religious accommodation. What do you think of that one? And then I'm going to ask you, where's the limit on that one going to end up being?
That's going to be something that would have to be granted if the religious need for it is valid, is truthful, is not just that's concocted, and as long as it's reasonable and doesn't overly burden the rights of other homeowners.
And these are going to be tough ones for associations, right, Sean, when maybe they're not so legitimate.
You can't just sort of make up a religion. You know, you maybe thought, well, they're going to deny it unless I claim that it's a religion. So, you know, it's got to be valid and legitimate, and that can be investigated. Applicant is going to have to show that it truly is for a legitimate religious purpose.
And this seems like one that you definitely want to get the attorney in on.
All of these accommodation issues, that is certainly going to be one that you're going to want to confer with the general counsel about.
Why don't you give us a quick closing thoughts?
You know, you're just going to want to carefully review that ARC application, make sure that it's complete, comprehensive, that it makes sense, that the procedural requirements for submission are included in there. You're going to have that timeline for approval. If the submission is incomplete, communicate that to the homeowner before the deadline runs. Make sure that the responses are clear and thorough. And if there's any variances at issue, be sure to consult with the association general counsel. Avoid selective enforcement, avoid arbitrarily denying an application, making decisions that are inconsistent with precedent from previous cases that have come up in the association in the past. Don't make members play the guessing game. Certainly avoid decisions based on personal preferences, personal viewpoints on taste.
Thank you. Thank you so much, Sean.
Have a good day.